everyone, this is Robert Weaver, and I wanted to do my Quiz 6 review for everyone today. And I'm going to be covering question 9 and question 11 on attempt 2. And I'm covering these two questions primarily to try and help out Courtney, who had some little bit of issue with these particular questions. So I'm hoping I can kind of clarify the answers for these questions for her. And so question 9 starts with, according to the textbook, which of the following is located on the landlord's real property would likely be included as part of the landholder's premises? So the answers that we can actually select from here and are, an operable car, family dog, residents of the home, trees, bushes, mailbox, water well, backyard shed, and single family home. So what helped me to answer this question was in the textbook, page 149, and the title, that is Duties of a Landowner. And it says specifically, the term premises refers to any real property and those things attached to or growing from it. So with this in mind, I looked at the answers, and the first one we can choose from, an operable car, means that the car can run. It can leave the property. You can take it off the property and return. It's not attached to the land. It's not growing from the land. So I automatically said, okay, that I know that's not an answer that I need. Family dog is a living creature. It can come and go from the property theoretically on its own. You know, and I didn't think that this dog would be attached or growing from the land itself. So I didn't pick that as an answer. The residents of the home also are living creatures, and they have the rights to come and go at will. They're not attached or growing directly from the premises. They're not part of. They may be part of the estate of the landowner, but they are not part of the land itself. So those first three answers I automatically dismissed, and I went down to trees and bushes, and obviously these are attached to the land. They grow from the ground, and if they're on the property, uh, they're attached and growing from the property. If they're attached to my property, those would be part of my premises or my land, or they could, be growing into an adjacent property, as the textbook alluded to, and I would still be responsible for those trees or bushes. And a mailbox, now we may not, automatically I thought, well, how can a mailbox be part of my premises? Well, a mailbox is used to exclusively service my premises. It's not a um, something that all my neighbors are going to use for their own enjoyment or pleasure, right? So it's used exclusively for me. So I consider this as being something that would grow from my property, even though we may think, oh, well, it's on the easement, it's on the sidewalk, that has nothing to do with my property. But I think the key there is, like I said, it services my property exclusively. So it's my duty to maintain it, so forth. And so I went ahead and picked mailbox as my answer. A water well is a natural occurring um, water table under the ground. Well, not a well itself. A well, I would drill down into the water table, but that water table may be um, part of my land or my property, and it's growing out from my property and maybe servicing other properties in the area or other landowners in the area, because you typically only own part of um, the land from, a piece of the land, right? And this water well may be underground and may be a mile long, it may be 2 miles long. Unless I own that mile or that 2 mile of property, um, it is growing from my property. Okay, so a backyard shed is artificial building, but typically it's attached to the land. This is not easily removable or movable. It has to be disassembled. Typically, you can't just pick this up and block off like it's a suitcase. So it would be a artificial building that's attached or growing from the land or the premises itself. And a single family home, also the same idea. It is a structure that typically is attached by a foundation to the land. It's not easily removable. It's usually typically sold as part of the land or the premises. And so those were the 5 answers that I chose. Uh, trees, trees and bushes, mailbox, water well, backyard shed, and single family home. And as you can see, I got 6 out of 6 points on this. I'm not sure. I believe Courtney may have chosen the same answers, but for some reason the system only gave her 5.25 points out of 6. So that may be something that Courtney would need to address. But I am going to go ahead and move on to question 11. And question 11 reads, under the premises liability laws of Mississippi, what is the Hoffmann exception? Now, this was a very difficult question because of all the different parts of the law that you really have to look at: strict liability, intentional torts, um, uh, statutes, limitations on liability cases. So let me just jump into this a little bit. And I went through a number of cases on Westlaw, and I came across the Hoffmann and Planters Gin Company. And in this opinion, it talks about invitees, trespassers, licensees, invitees onto a property. And I kind of had to um, deduce from the opinion really what they were kind of trying to get to, and because it does, like I say, talk about licensees, trespassers, a licensee, and an invitee. And uh, it from what I saw in other opinions, it's common law in dealing with trespassers, invitees, and licensees on the property, that it appears that they would all be treated the same. And or I'm sorry, not the same, but they would be treated differently under certain minor exceptions, right? And in this opinion, it says there are a good many dicta, mostly in older cases and some holdings, to the effect that the occupier of land owes the bare licensee no greater duty than to refrain from intentional, willful, or wanton misconduct towards him. And that seems to be the statute in Tennessee, that if you have a trespasser on your land, you can't set traps for them, you can't hurt them um, in any way for being on your property. And the prevailing view is to the contrary, however, and it is now generally held that in cases involving injury resulting from active conduct as distinguished from condition of the premises, landowner or possessor may be liable for failure to exercise ordinary care towards a licensee whose presence on the land is known or should reasonably be known to the owner or possessor. And since this case specifically talked about a trespasser, a licensee, and an invitee on the property, what happened in this case is a 14-year-old child he comes onto the owner's property, and is subsequently he's injured by an auger in a gin um, while he's on the property. And a possessor of land is subject to liability for his licensees or physical harm caused by them by his failure to carry on his activities with reasonable care for their safety, if but only if a he should expect that they will not discover or realize the danger, and B, they do not know or have reason to know of the possessor's activities and the risk involved. So this child was hurt, and what they're saying basically here is the landowner has knowledge that the invitee doesn't have. So even if he warns them and they get injured, essentially he could still be liable for their injury because he failed to um, give them reasonable or is a reasonable care while they're on his property and warn them of dangers on his property. And basically, in this opinion, what I saw is they were trying to say because the son went out of the normal bounds of being an invitee because he invited them into a tunnel and basically warned them to stay out of the auger. The son went into the auger, and he was trying to say that the son left the bounds of an invitee and became a licensee because he didn't heed the warning of the landowner in this particular case. And the court found, as commented on to the above, it is stated the possessor of premises need do no more than exercise reasonable care to warn a licensee of his intention to do an act which he should realize is likely to cause harm to the licensee if he comes into or remains within the area in danger by it. The possessor is entitled to expect that such warning will cause the licensee to avoid the danger unless the possessor realizes or should realize that the warning would be ineffective, either because of the danger is so imminent that the licensee would have no opportunity to avoid it, or because the licensee does not hear the warning or is not able or does not intend to take advantage of it. So going back to the answers, I looked at these. So it's a special circumstance where a landowner commits an intentional tort of self-defense. Well, we know that from the Hoffmann case, he's not. It's not an intentional tort. He's not defending himself. So that was an answer. I decided, okay, that's not going to be the answer. It's a special circumstance where landowners are subject to strict liability for injuries on their premises. And I didn't think this was I kind of got stuck on strict liability because I thought that was more of a product liability than would be in this case. So I said, no, I don't think that's the answer. And it's a special circumstance where someone who doesn't own the land may still be liable for injuries on the premises. And that didn't make any sense because we're dealing with premises liability specifically for this chapter, and you know, why would I would be liable to the landowner if I did something to damage his property, but why would I be liable to, say, my buddy who goes onto the land with me and he falls and breaks his leg? Why would I be liable to him? So I didn't think this was the answer. I kind of dismissed it. It's a special circumstance where the statute of limitations is extended for premises liability cases. And I didn't see this in any of the opinions or any of the head notes that I looked at. So I said, no, that's probably just a red herring. I'm not going to try and chase that down. And it's a special circumstance where invitees lose all rights to recover from premises liability. And I didn't see that in the opinion as well. He's not losing his rights. It's in essence, the court is saying that the owner owes him more, just as if he was an invitee on the property. You know, the landowner has to protect him just as if he was an invitee, even though he's a licensee, or even as we see in Tennessee law, even if you're a trespasser, the landowner can't set traps. They can't try and hurt you in any way just because you're on their land doesn't mean that they can shoot you. You know, um, and so I didn't think this didn't make any sense to me really at all in terms of an answer for me. It's a special circumstance where landowners are immunized from premises liability. And I didn't see this as well in any of the opinions on Westlaw that I kind of skimmed, and where they wouldn't be held liable. Even in the case of a trespasser, they would, if they harm that trespasser, they would still have some type of liability attached to them as a landowner, because they have to warn against, even natural occurrences on the land that could potentially hurt someone, right? So, and the next answer here, it's a special circumstance where the trespassers can assert premises liability despite their unlawful entry. And that's true. In the case, if they were a trespasser, in this case, they were invitees onto the property. And we know already from statute, like I said, that a trespasser has a certain right to, you know, um, not be hurt, even though they're on your land illegally. They still have certain rights that you can't willfully or wantonly harm them. And the last answer we can choose from, it's a special circumstance where licensees are elevated to invitee status. And I looked at this and I kind of thought about it, and I was like, my gut said this has got to be the answer that I'm looking for. And I know I wish I had a better way of explaining why I picked this answer, but this is kind of what I went for in my gut feeling is licensees are not necessarily trespassers, they're invitees onto the property. And because it was talking about how a lot of what I saw is um, they were, you come in as an invitee, but you kind of go outside of that. And there was one case where a girl came on to visit somebody. She went and checked out some other rooms, if I remember correctly. Unfortunately, very sadly, she's raped in that particular case by a guest at the hotel. And they were saying that she left her status as an invitee once she started walking around the hotel. And so, kind of coupled with all that information and looking at specifically the Hoffmann uh, v. Planters Gin Company case, um, I said this must be the answer, and I did select it. And as you can see, I got 6 out of 6 points. So I'm hoping this clarifies a little bit for everybody who may have missed it. I probably confused you more, but I hope it does help. And that's my quiz review. Thank you everybody for watching. Take care.